do you know what a smoking submarine is? Do you have any comments about it?
What?
There have been allegations about the misconduct of the submarine.
What?
Please answer me. Where are you going so fast?
No, I got a court case. I got to reply with my lawyer.
One last question. The family members of the crew members of the submarine have been in a very devastated state. Do you have any explanations to that?
No, you don't ask so many questions. Which publications you're from? Huh? Why you ask so many questions?
You ask so many questions.
I'm YB.
Where are you going? Why are you so rushing?
I'm very busy. You don't. Goodness.
In the United Kingdom, it is fair to the citizen that they can always question the court about the fairness of a certain case. In a case, when they feel that their rights have been infringed, they can always ask for an appeal before the court. However, in cases that involve public bodies, they cannot ask for an appeal, but they can always ask for a judicial review. A judicial review, in layman terms, is a court proceedings that allows the judges to review upon the lawfulness of the decision made by a public bodies. However, public bodies such as government ministers can always have their right to refrain certain information to be disclosed in a judicial review proceedings. This is because they can claim that the information to be disclosed is under the public interest immunity. A public interest immunity is one of the means to let the government to refrain to disclose any information upon the court. Such claims are laid under the Crown Proceeding Act 1947. It is an important note that the public interest immunity was previously known as the Crown Privilege, which gives the Crown a way and a privilege to disclose any information and have a way to deter the information and the oral evidence to be disclosed in the court. The trend of public interest immunity started since the case of Duncan and Camelot, where in this case, the House of Lords held that the public interest immunity certificate issued by the public bodies is final, conclusive, and not to be questioned. So, this tends to let the Admiralty to escape from disclosing the information to the court. Hence, public interest immunity seems to be favoring to the government, and government ministers always use this as a loophole to escape from problems and questions from the public. Therefore, it is always viewed that public interest immunity will bring unjust and unfair decision in the court. So, in today's video, we will discuss about the contemporary and continuing concern of public interest immunity and how public interest immunity has evolved over the year.
In Duncan and Camelot, the court sought to disclose the document in respect of contracts between the Admiralty and building contractor along with the salvage report. However, the Admiralty refused to disclose the data depending on the national security, and the minister claimed that the disclosure of information is not in favor of the public interest. Provided that the court does not disclose any information, it falls into a grey area, and there's an urge that to raise public interest immunity to protect the information. Consequently, the rule that the court of law could never question is now considered as public interest immunity. In 1956, Lord Kilmer has actually differentiated between two documents which were actually essential to the civil service to function in a proper manner. Documents which were closely connected to the proceedings but utmost confidentiality for the sake of public interest is not necessary. Moreover, documents related to the medical and criminal proceedings should not be claimed. The rule in Duncan and Camelot prevailed until 1967. Besides that, in Conway and Rimmer, the House of Lords overruled its past decision in previous case and actually depart from its own precedent in the past. The courts have actually the final say in deciding when content and class claim are affirmed. This was supported by Lord Reid, which he made comment regarding the Attorney General at that time, whom he suggested that the use of Crown privilege, documents and evidence can be used and can be disclosed in criminal proceedings but possible to withheld in civil proceedings. In addition, Lord Reid also stated that the use of Crown privilege is not to protect the documents as its content are public property, but it is used to protect the writer of document from civil liability. Furthermore, in the case of Makanjola and Metropolitan Police Commissioner, the applicants and party involved actually have disadvantage because they are not aware of the terms and application of public interest immunity. Though the case law may provide some pointers on how the public interest test should be satisfied, but it is not enough to determine whether the claim will be succeed. Additionally, the public interest test is the most system which is in control helped by obtaining the information by government are based on the same building blocks. Public interest test is the right to obtain exemption such as security issues, formulation of government policy, and international relation. Though it may be argued by some of the applicants that taking public interest into the account may outweigh exemptions and the information should be released. Other applicants may not pinpoint the consideration of public interest accurately. It is worth mentioning that the Information Commissioner has the right and power to decide to what extent the public interest by using its power and discretion. The Information Commissioner has the power to overrule the public authority of an exemption such as the application of the public interest test. However, public interest immunity undoubtedly raised several criticisms. The absence of public interest immunity has the effect of removing insignificant evidence and does not make changes to the scope of inquest. The downside of the successful public interest immunity application is that some of the evidence will be not exposed to public scrutiny. Moreover, public interest immunity is in breach of Article 6 of European Convention on Human Rights, right to fair trial. For example, in the case of Magic Churchill, the judgment was unfair to the claimant because public interest immunity was raised to conceal an important evidence. Applicants have also raised Article 5, where they will have a right to challenge a decision which is based upon the disclosure evidence. Although public interest immunity could give rise to miscarriage of justice, the court could use methods to prevent misuse of public interest immunity such as judicial review, where the judiciary examines whether the public interest immunity claim is legitimate.
You and I have been seeking for a government that conceals nothing from us, as it works in the best interests of ours. However, Lord Wolf, in
The case of ex parte Villi
stated that both disclosing and withholding of information are not opposing idea of public policy. Instead, they are only different perspectives of the public policy. The main idea of public policy is to prevent the society from running amok. In the event of withholding information, the perspective which favors towards the withholding of information to protect the function of public service outweighs the perspective of disclosing information for the use in litigation. Therefore, the government is required to weigh the public interest when deciding whether to disclose information or not. On the other hand, the court in Air Canada and State for Secretary of Trade stated that the government who required to disclose information must show that the document required can give enormous amount of support to the argument that they have in the case. It is not sufficient to merely say that the documents required are related to the case. Therefore, the requirement for the government to disclose information is by establishing that the documents required are very likely to help in the case. On another perspective, Lord Justice Bingham in Makanjuala and Metropolitan Police Commissioner stated that the party asserting documents are disclosed or withheld on the public interest ground isn't actually a right or privilege, but it's actually a duty. He went on to say that a right can be waived, but such a duty can never be waived. Secondly, a litigant who holds an immune document should exert its immunity, as it is for the court as the final judge to waive its public interest. Thirdly, if a document is immune, it may not be used in the proceedings of the court at all. However, unlike the readings in Makan Juala, practically the government and the ministers do not have the duty to claim public interest immunity. The ministers can and do decide whether to claim the public interest immunity. For instance, the public interest immunity wasn't claimed in and Home Office, where the minutes being briefed by the civil servants to the Home Secretary were disclosed to the public. It is in fact normal for the ministers to disclose the information or documents where public interest immunity might have been claimed. But it is only when in court his counsel is required by law to prevent the disclosure of information or document when the duty to claim the public interest immunity arises. That cannot be the law. Despite the odd reluctance in overruling Makan Juala, the government's announcement and the abolishment of such stance is, however, clear enough. Right now, the public interest has to be weighed before the duty to claim public interest immunity arises. Subsequent to the announcement of the government, there should be a ministerial certificate containing a real harm or damage to the public interest in detail when claiming public interest immunity if disclosure is required. In a nutshell, as we can see, the development of the disclosure of document by the government has been moved from the control of the minister himself towards the court. It actually translates to a better accountability by the minister when they're making a decision to whether disclose the information or withhold the information.
Oh my god, the submarine case. YB, now how, YB, how?
What are the journalists doing? They're wasting their time.
But what about the court case? It's going to be 2 hours later. Shit.
Shilla. We can claim for public interest immunity, right?
Public interest immunity? What is that?
Later, you will know in court.
Oh?
Ayo, my deepest condolences to you and your family. Stay strong. Stay strong, girl.
I don't want him to die. My honey died.
Ayo. Don't cry, it's okay.
The case that is bringing forward today is GB and Home Secretary. The issue in this case is the submarine sank and there are 67 casualties. The claimant may submit your case. No! Tell me! Why my husband died?
I'm so sorry, but the Home Secretary has made a decision to claim for public interest immunity. Thereby, will refrain from disclosing any information.
Public interest immunity is actually the privilege of the government, as mentioned by my previous group member in the case of Duncan and Camelot. However, it is important to note that at that point of time, there was actually an Australian case, namely Robinson and South Australia, whereby the court was to the decision that they should have the reserve power to inspect the document and also make decision as to whether such claim is justified. However, since the case is from an Australian court, it is merely persuasive in nature and therefore such decision was not being followed. And the practice in Duncan and Camelot are being continuously exercised in a later case such as Bitson and Skene, as well as Ankin and London North Eastern Railway. The liberal approach emphasized in the Robinson's case was only referred to when Conway and Rimmer overruled Duncan and Camelot. The reasoning behind this is because the court appears to be in a better position and to make decision as to whether the evidence ought to be made available to the court of law in order to ensure that justice will not be omitted. This is a very good illustration that the courts are break away from the restrictive view in the sense that the government is no longer having the final and conclusive say. Such change is good in the sense that there will not be abuse of such power where previously the government might simply assert that particular information fall within an area in which the information need not be disclosed. Besides that, the third postulates of the rule of law of evidency seems to be upheld to a greater extent because the court is still the ultimate body in securing the individual's rights and to evaluate the merits of the claims. Apart from the discussion above, it is also important to note that there is a greater portion of the claim in civil cases compared to criminal cases. In most of the circumstances, the parties are required to disclose all of the materials in criminal proceedings because fairness is exceptionally important. However, in the case of ex parte Osman, where the judge was to the view that public interest immunity should be exercised in criminal proceedings as well. And the use of public interest immunity was different with that in civil cases in the sense that the prosecution have the final say. Such practice was being criticized in the sense that there might be unfairness to the defense because the defense might have no knowledge as to the withhold of the documents, and this was actually contradicting to Article 6 of ECHR, right to a fair trial, because they might be put at a disadvantaged position in which the prosecution might withhold significant documents, which was actually in favor of that to the defendant. This unsatisfactory regime was actually being considered in the case of R against Ward, whereby now the prosecution have to notify the defense as to whether there is any documents being withheld. This is good in the sense that the court could actually look into the prosecution's allegation and to inspect the legitimacy of such allegation. Besides, in the case of R against Davis, the courts actually established the procedural implications such as the indication of certain categories in which the documents can be withheld. Besides, in the case of R against Keane, the courts actually discharged the function in inspecting the non-disclosure of the material, and lastly, the scrutiny of the courts was also being emphasized in the case of R against Turner. The Criminal Procedure Investigation Act 1996, as amended by Criminal Justice Act 2003, was also worth mentioning because these two statutes actually sets out a clear framework governing the non-disclosure of materials in criminal proceedings. In R against H&C, the House of Lords actually established a golden rule which states that every material has to be disclosed, and such disclosure even extends to those which are unused. The unused material will only be prevented from disclosure if it involves national security or identity of witness, etc. Based on the discussion above, it can be seen that the evolution of PII in criminal proceeding was actually quite satisfactory because it encouraged a more transparent and fair process in the criminal proceedings. Besides that, there are also statutes being enacted to ensure the fairness and prevent any abuse of such power by the prosecution. Therefore, the Criminal Cases Review Commission actually held that any disclosure of the materials during criminal proceedings is very important because failure to do so by those who are entitled to is actually one of the biggest single cause of miscarriage of justice.
In the past, there had been a contrast between contents claim and class claims to public interest immunity. The difference is where contents claim damage the public interest as to the contents of the documents being revealed, whereas class claim is where the disclosure of document does not cause any harm to the public interest. Though class claims raised a candid argument where disclosing honest reports would discourage the executive, but it was shut down by Sir Richard Scott. Besides, class claims in respect of national security and central government documents were abolished due to the criticisms that it will create public or political criticism as to the disclosure of relevant document, and sensitive material was protected by contents claims. Hence, there was no need for class claims to be made, and the breadth and elasticity of these claims are questionable. Despite such abolition, class claims were still applied, though the court had to be more skeptical and cautious as to when class claims are made. Moreover, the duty to claim public interest immunity arises. It is said that to claim public interest immunity is not affirming a right, but to fulfill a duty rather than a discretion. In the case of Makanjala against Commissioner of Metropolitan Office, Lord Justice Bingham stated that public interest immunity is not a privilege for government to use as they like. It is a duty imposed even though it is to their downside. This meant that the executive cannot waive public interest immunity as one cannot waive duties, and where the immunity applies, the relevant document cannot be used for any purpose in the proceedings. However, there is no obligations for the executive to claim public interest immunity, as they have a freedom to decide whether to claim it. For instance, in the case of the sinking of the General Belgrano, public interest immunity was not claimed and the crown jewels was omitted in evidence. Similarly, in M against Home Office, public interest immunity too was not claimed. This occurs when the disclosure of evidence has a greater public interest on full account of disclosure. To conclude, the executive has a duty to consider public interest involved before claiming for public interest immunity. However, the court still have the final say in deciding whether a claim of public interest immunity succeeds rather than the executive to maintain the balance between the public interests. Furthermore, where the government thinks fit, the executive has the power to override a prosecution by declaring public interest immunity. In the notorious case of Matrix Churchill, the broad duty of claiming public interest immunity made it possible for ministers to claim public interest immunity as the document fell within a recognized class, as so the ministers had a duty to claim so. Though the decision to claim public interest immunity lays in the court, the judges in this case were reluctant to overrule the ministers, which led to the defendants getting away unconvicted. This case has been said to be an abuse of unaccountable power by government officials. Therefore, a judicial review of the Scott inquiry undertaken by Sir Richard Scott was ordered by the government to examine the legitimacy of the ministers' use of public interest immunity certificates in this case.
In conclusion, although the justiciability of public interest immunity had always been questioned by the general public, but the biggest concern of why the government is still using it until today is because they tend to refrain any information that is considered as their official secrets to be exposed from the general public. However, in some cases, as discussed by my teammates, such as the case of M against Home Office, the court tends to fill the claim of public interest immunity in this case because it was stated that the disclosure of information in this case will be greater than its immunity to the general public. Also, as what Lord Bingham said, the public interest immunity is not a privilege for the government to use as what they like. In conjunction of what he has said, if the government continue to use the public interest immunity to run away from problems and questions, this will cause the general public to lose their confidence towards the government today. Hence, it is important to the court that they need to have a check and balance between the public interest immunity and the interest of disclosing a certain information to the interest of the general public. The legitimacy of the use of public interest immunity certificate needs to always be challenged by the courts so that the abuse of power by the government can always be limited, and cases such as Matrix Churchill, as discussed above, will not happen again. Consequently, the fairness and justice can always be ensured, maintained, and built in the country.